Hello, good afternoon, everyone who's out there. At this point, the numbers are growing. Welcome to the third in the series of webinars on topics that are important to developers in California and everyone for that matter. My name is Ben Reznik, and I'm a partner and I'm chair of the Jeffrey Mangels, Butler, and Mitchell's land use group, and actually it's a whole department. And today we're going to be covering two very important housing laws, the Housing Accountability Act and the Housing Crisis Act. Slide, please, I guess. I don't have control of moving the slides. Thank you. For those of you who are new to this webinar, let me just say we started it this year, and the response has been amazing. So we're very much encouraged to continue it throughout the year. We've had in the last webinar nearly 100 people signed up, and today we're about to reach that number as the numbers keep growing. Just a quick word about who we are. If you're not familiar with Jeffrey Mangels, Butler, and Mitchell, the firm's been around for nearly 45 years. We are a full-service business law firm. I'll focus on business matters with multiple departments. We have departments in corporate law, litigation, labor and employment, real estate, tax, estate planning, bankruptcy, and of course, the best functioning department is ours, is the government land use environment and energy department known as GLUI. So what's the next slide, please? What's a little unique about, I think, our group, and we're very proud of it, is that over the years, we've been able to assemble land use lawyers who bring some very unique talents to the table. They're people who've had maybe a second profession. Many of our land use lawyers are people who are either an architect, we have one. We have a civil and structural engineer who's a lawyer, land use lawyer. We have someone who used to do EIRs for 10 years before becoming a lawyer. We have a lobbyist who used to be a lobbyist and then became a lawyer. We have a municipal lawyer, someone who represented cities for many years, then became a land use lawyer with our group. And so we're very proud to have pulled together a unique group of land use lawyers. We operate throughout the state. We have offices in San Francisco, Los Angeles, and Orange County. And so also the types of cases we deal with just are all over the map. It could be land development, be residential, commercial, industrial, energy. It can be mining. We're very big in the mining industry. The point being is that we see our expertise not limited to a particular industry or segment, but to anybody who needs that kind of use. And so with that, just note that we have a few more programs planned for you this year. There they are on the board right now. And we also would appreciate if you want to hear something special, some particular topic, if you would email us, we will consider putting that on. And so without further ado, our speakers today are going to be my longtime law partner, Matthew Hinks. Matt Hinks has been practicing for over 20 years in our firm. Matt has probably handled some of the highest profile land use litigation matters in the state, certainly in the region. He deals with property rights and real estate disputes, and a real pleasure to work with, I gotta say. Clients love this guy. Our next partner is Daniel Freedman. Daniel's been practicing with us for 10 years now. Well, he has 10 years of experience. He's a land use lawyer, does a lot of the transactional stuff, dealing with entitlements, dealing with outdoor advertising, historical resources, industrial, commercial, mixed-use developments, all of that. And very proud to have Daniel on the team. And of course, if you're looking at the screen in the upper right, the handsome face there, that's me. I'm the chair of the department, actually, founder of this department. Some 25 years ago, I joined the firm. I've been practicing now for 46 years. And I have to say, The reason it doesn't get old is because I get to work with people like Matt Hinks and Daniel Freedman, who you're going to hear from in a minute. And so a couple of items of technical information. You can send questions during the presentation. In this box you see, it says ask a question. If you write it in there, we will review it. We'll try to get to it and answer it. And lastly, there are some helpful buttons at the toolbar across the bottom of your screen, which will allow you to share this program with a colleague and to also get in touch with us. So having given this rather lengthy introduction, it is 12:06. I'm going to turn it over to Matthew Hinks to get us going. Matthew.
Yeah, thanks, Ben. So the title of this presentation is using the Housing Accountability Act and Housing Crisis Act to get your project approved. And what I want to do over the course of the next, 50 plus minutes or so, is I want to take a pretty deep dive into the HAA and into the Housing Crisis Act, otherwise known as SB 330. You might be more familiar with SB 330. But I want to take a fairly deep dive into the two statutes. They're a subject that's they've been in the news. They're fairly significant in terms of we're seeing lots of issues arise under the HAA and SB 330. And the reason is because these are new statutes that have been enacted by the legislature over the course of the last several years. In the case of the HAA, actually the HAA has been around a while, but it's been significantly amended over the course of the last few years. And as the legislature has amended the HAA and enacted SB 330 and all of the other spate of housing legislation that we've seen coming out of Sacramento, they've done that. And by doing so, they've significantly altered the playing field when it comes to local agency action on housing development projects. Because what the new laws do, and especially the HAA and SB 330, is that they eliminate much of the discretion of local jurisdictions that they once had over qualifying housing projects. And they require that local agencies approve most of these housing projects that fall within their protection. So, I hope to provide some tips along the way as to how you can bring your project within the scope of the HAA and increase the odds that your project is going to be approved, because it is subject and governed by and within the protections of the Housing Accountability Act. And look, when it comes to the HAA, it's really a matter of knowledge is power, and it really behooves you. I mean, if I assume that there's people listening who have housing projects, or developers, or thinking about developing housing projects, or maybe consultants or expediters or lawyers who are representing developers and who have a hand in housing development projects. And it really behooves you to understand the playing field, because there has really been significant changes made to the process and the power dynamic when it comes to the review of housing projects. Just a quick story. I had a client that came to me recently, and they said, they said, Matt, I got a housing project. They had been several hundred units with a significant mixed-use component. They had been in the city of Los Angeles, been in the process for several years, had been through public hearing after public hearing after public hearing. Finally, a couple of years ago, got their project approved. And once they got their project approved, the city said, well, sorry, but we've got a new ordinance now. You got to apply for this new entitlement under this new ordinance, but trust us, you're a shoe-in. There's a lot of support for your project. It'll be approved. Don't worry about it. Just go ahead and apply and move forward with this process. I'm a litigator, so you probably know where this story is going. The politics turned on them, and suddenly they found themselves in a place where the city council was moving to deny their project. Now, had they called me and got in touch, or had they been attuned to the Housing Accountability Act and SB 330 and those provisions 2 years ago, when the city came to them, told them they got this new ordinance, that this developer needs to apply under, the answer should have been, that's all well and good, but you can't apply it to my project. I've got an approval. You can't make me you can't make me apply under that. Thank you very much, but no, no, thank you. And unfortunately, they didn't do that. Caused that developer a lot of money, a lot of time, a lot of grief. But anyway, so a little lesson to why you want to be aware of what these new laws are all about. Okay, let me move forward. So what is the Housing Accountability Act? I think I moved forward one too many. Okay, this is the overview of the Housing Accountability Act. What is it? Okay, it codified at Government Code Section 65589.5. I think that there's a link somewhere somewhere that's available. I'm sure our producer will let you know if you're a masochist and you want to sit down and read through it. It's there. I'll warn you, it's difficult, it's dense, it's non-linear, so it's not exactly it's not easy to understand. But that's it's one of the reasons why I want to go through this today. Hopefully, the things that I'll go through will make it a little bit easier for you to understand if you have that time and you want to read through it. But the point is, it was enacted in 1982. It's referred to as the Anti-NIMBY Act. So it's been around for 40 years. But as I said, it's been amended several times since its original enactment. And the most substantive amendments have come since 2017, as the legislature has been dealing with the well-publicized housing shortage and housing crisis. And so they've over the years, and they continue to add to the Housing Accountability Act. They continue to add new laws such as SB 330 in order to facilitate the development of housing, and again, to eliminate local agency discretion and to substantially restrict the bases upon which an agency may either deny a project or reduce the density of a housing development project. So the first thing that I ask when a client comes to me and says, "Hey, I've got this project. Am I protected by the Housing Accountability Act?" First question I ask is I think which I think is the fundamental threshold question is this project a quote unquote housing development project? And that's capital HD, capital P, right? So that's a defined term in section H2 of the HAA. And it says that a housing development project is one of three things. It's a use consisting of any of the following: either residential units only, a mixed use development consisting of residential and non-residential uses with at least 2/3 of the square footage designated for the residential use, or is transitional housing or supportive housing. So out of the transitional housing, supportive housing, there's further definitions for that in the government code. Essentially, those are low-income housing that's also tied to a service, a medical service or job service or something like that. Typically, if you're a proponent of a transitional or supportive housing project, you're probably not looking to the HAA to get your project approved. You probably got some political support behind you. So really what we're talking about are the first two, which are residential units only or mixed use developments in H2B. So a couple things that I notice when I look at these definitions. First off, residential units only, obviously that's pretty understandable. Typically it's apartment projects, condo projects, but it also could be single family home projects. Now notice that it uses the plural, residential units only. So because of that, the state housing board interprets that provision to mean it applies to, as long as you've got two housing units on a lot, you're going to come within the protections of the HAA. So that means a single family home with an ADU, you're an HAA project. An SB 9 project, it's two single family homes on a single lot, you're going to be an HAA project. So that's residential units. Now, mixed-use development consisting of resident. Yeah.
Sorry to interrupt. You know, you and I have discussed this at length. I completely disagree with the HCD's interpretation of that. I don't read it as 2 units. I mean, that is how the state is interpreting it. But I personally, I think a single unit would be a project that's comprised of residential units only.
Yeah.
And I would add also that would include, they have interpreted it to say that also includes ADUs. So a single family home and an ADU would meet the 2 unit standard the state has interpreted this to be by. But
yeah.
Matt, just on that point real quick, and because section B here also talks about the second definition as mixed use developments in the plural, the whole setup here is just talking about developments in the plural, not in the singular. So I agree with Daniel. If we ever have to challenge HCD's interpretation, I think we have something to work with here.
Yeah, yeah. I mean, all good points. And as I said, that's an HCD interpretation. There hasn't been a court case that I know. Certainly, there hasn't been a reported Court of Appeal binding decision that has interpreted residential units only. Thus far, the only guidance that I know about is HCD, and they say 2 and a lot. But you know, good arguments for why it should apply to just a straight single-family home project as well. But looking at mixed use developments, a couple of things there stand out to me. One of them is, so notice the difference in the phraseology. Residential uses, which is a change from residential units, which suggests to me that you're talking about, or potentially could cover, different types of non-traditional types of housing, such as group housing arrangements, because we're not looking for residential units, only residential uses. So there's a potential that the HAA may cover non-traditional types of housing. And then notice also as well, when we think about mixed use developments, we typically think of residential combined with some kind of neighborhood commercial uses, an apartment building with a Starbucks on the first floor. But it doesn't say commercial. It actually used to say neighborhood commercial, but it was amended somewhere along the way, and now it says residential and non-residential uses. So, it could potentially extend into industrial. So long as there's a residential component, industrial, institutional uses. We actually had a case for a client where we convinced Ventura County Superior Court judge that an assisted living housing facility was a mixed use development under this definition. Now that's, it's not how we think of a mixed use. We wouldn't think of an assisted living facility as a mixed use development, but came within that definition. It read onto that definition. And so that client had been denied a CUP for that project. And once we got that ruling from the Superior Court, they're now developing that project. Okay, so there are, let's say you've got a housing development project. Now what? There are 2 types. There are 2 potential ways you can qualify for protection under the HAA. You can either be a subdivision D project or a subdivision J project. Both of them, the threshold question is a housing development project. Subdivision D deals with affordable housing, and subdivision J deals with both affordable and market rate. It deals with projects that are compliant with objective requirements of the zone. I'll go into more details of both of that. So I'm going to start with subdivision D, affordable housing projects. And by the way, you want to be in subdivision J. Subdivision J is where the action's at. Subdivision D has existed in the HAA for many, many years. It hasn't been the subject of a whole lot of, I would say, scrutiny, court cases. There hasn't been a whole lot of issues that I've seen arise under subdivision D. Really, the actions in subdivision J. But let me just go over subdivision D and point out a few things. I'm going to move forward a little bit. So this is what you have to do to qualify under subdivision D. You got to be an affordable housing project with at least 20% of the units sold or rented to lower income households as those terms are defined under the Health and Safety Code, or 100% of your units have to be set aside for middle income households, moderate income or middle income, depending upon how those terms are defined under the Health and Safety Code or the government code. So it's either 20% set aside low income or 100% at moderate income. One thing that I've noticed about this subdivision D is that y'all might be familiar with density bonus law. Density bonus law is a state law that says that the local government must give you an increase in density over the maximum allowable density over the zone, depending upon the amount of set aside that you're willing to provide. But the HAA calculates it differently, whereas under the density bonus law, you're calculating you're calculating the set aside units based upon the set aside units. In the HAA, it's the total number of units. So what that means actually is that just because you're qualified under the density bonus law because you've got 20% set aside, that may not be enough under the HAA. So I had a client find that out the hard way. So that's something to keep in mind. Going back, so say you got a housing development project, you qualify as affordable because you got 20% or the 100% set asides. Subdivision D says these are the bases. Well, let me put it the other way. An agency shall not deny an affordable housing project or condition it in a manner to make it infeasible unless it makes written findings as to one of the following. So in other words, these are the 5 bases upon which an agency may deny your project. And if they can't make these findings, they can't support these findings, their obligation then is to approve your project. So and that's so what it does essentially is it preempts local laws. So if the local laws give the agency the discretion to deny your project, subdivision D says, well, no, notwithstanding your local laws, you shall approve this project. You can't apply your local laws to deny your project. And so these are the bases. And one of them is, and this is probably a pretty major one, the local agency is meeting their RENA numbers. Now, not all of them are doing that, obviously. I think that's been in the news recently. But if the agency is meeting their RENA numbers in that income category that you proposed, and their local laws allow them to deny their project, exercise discretion to deny your project, the HAA is not going to stop them if they're meeting their RENA numbers. The other grounds are the project would have an unmitigatable adverse impact upon public health or safety. We'll see that a lot in subdivision J because that's the only ground in subdivision J. 3, denial is required in order to comply with specific state or federal law. I don't know what those might be, although I suppose it might be laws such as the Coastal Act or CEQA might provide a basis for an agency to deny a project. Project is proposed on land zoned for agriculture is another ground. And then the last one here, 5, this is actually incomplete. This says the project is inconsistent with the jurisdiction zoning ordinance and general plan. There's actually a second part to that. It says the project is inconsistent with the jurisdiction's zoning ordinance and general plan, and the agency has a compliant housing element. Again, a subject that's been in the news recently because I think we've seen a lot of jurisdictions been determined that a lot of jurisdictions don't have they're going through the update and they're not in compliance with their housing elements. And so if that's the case, then there's an argument here that says that by negative implication, even if your project is inconsistent with zoning or general plan provisions, if that jurisdiction is not in compliance with their housing element, this is not going to be a basis for them to deny your project. I've heard this referred to as what's called the builder's remedy. I have yet to see it work. I don't know if it would ever work. There are actually other provisions of the HAA that are in tension with this, and so I don't know. As I said, I've never seen it work. But that's a subdivision D project, affordable projects. So let's move forward and let's actually talk about subdivision J, because this is, as I said, this is where the real action is. This is where all the amendments have taken place to the HAA in recent years, and there's other standalone bills such as SB 330, which I'm going to talk about more in a bit, are all focused on getting projects approved through subdivision J. So what is subdivision J? So first off, subdivision J applies to both affordable and market rate. So there's no affordability requirement whatsoever under subdivision J. And here's what it says, and this is the money provision. An agency must approve and not reduce the density of a housing development project that complies with, quote, applicable, and I've bolded and underlined this word because this is important, applicable objective general plan, zoning, and subdivision standards and criteria, including design review standards in effect at the time the application was deemed complete, unless the agency makes these two findings. And I'll get to those findings in just a second. I just want to focus on this provision here for a second, and what does it mean? Well, first off, I think the focus here is this word objective. Objective general plan, zoning, and subdivision standards. So if your project is consistent, compliant, or in compliance with objective general plan and zoning standards, then you're going to qualify for protection under subdivision J of the HAA. And what does objective? Objective means that it's not subject to discretion. It means a standard that involves no subjectivity, no personal judgment. It's usually going to be things that are attached to a number. So think of height, 30 feet, 45 feet, whatever it is, FAR, minimum lot sizes, setbacks, parking requirements. If your project is consistent with those objective standards, the agency shall approve your project unless they make these two findings, which I'll get to. So that's the key. It's the objective standard. So in other words, if the agency is also, the agency laws require that you're applying for things such as a site plan review, such as a specific plan review, a design review, all of these requirements in which the local agency planners and planning commissioners have discretion over your project. The HAA as long as your project is consistent with objective standards, the HAA is going to preempt those local laws, and they're going to prevent local governments from denying your project or reducing the density of your project based upon those subjective criteria. That sort of in a nutshell is, how subdivision J works. There's more to it. I'm going to get to it, but that's the real key, objective requirements. So, if you're thinking about a project, if you're designing your project, you got to keep in mind the objective standards, the objective zoning and general plan standards. And if you can meet those objective standards, you are not guaranteed, but you're almost certain to have your project approved, notwithstanding local laws, local opposition that might stand in your way. You're probably going to get that project approved. The other thing I want to point out in this provision is the last part where it talks about standards and criteria, et cetera. In effect, at the time the application was deemed complete, which provides you with it's a type of vesting. So it means that once your application is complete, your housing application, you got to complete a housing application, it's been deemed complete, and I'm going to get to that because SB 330 has a lot to say about that. You're now vested, and the agency cannot enact new laws and apply those new laws and force you to comply with the new laws that come into effect after your application was deemed complete. That was the central error of my client that called me that I talked about at the beginning of this. there was a new law that came into effect, and they decided that they were going to comply with it. When the answer could have been, thanks but no thanks, that doesn't apply to my project. Okay, so now you've got a housing development project. You're consistent with all the objective requirements of the zone. Now what? Now an agency must approve the project unless they make these two findings. One, the project would have a specific adverse impact upon public health or safety unless the project is disapproved or its density is lowered. And two, they have to find that there is no feasible method to satisfactorily mitigate or avoid the adverse impact. That is an incredibly narrow standard. Public health or safety requires them to deny your project, and there is no feasible method to mitigate or avoid the adverse impact. A very narrow ground upon which an agency can deny a project that's compliant with objective zoning standards. I'll show you some other reasons why that actually make that even more narrow than it might otherwise read. I have yet to see a court uphold a finding made under subdivision J that a project would have specific adverse impacts that can't be mitigated. I have yet to see a court uphold those findings. So very, very narrow findings. That's why I say if your project meets those objective standards and criteria, you're probably going to get that project approved. Notice of inconsistency. If I could bold and underline and shout out and put a bunch of exclamation points on this, I would, because I think that this is extremely important, and one of the most impactful things that exists in the HAA. One of the most impactful things that I see, most developer-friendly things that I see exist in any kind of land, and it works a very radical change to how agencies must deal with housing projects. And so this is what it says: if a local government considers a proposed housing development project to be inconsistent, non-compliant, or not in conformity with any applicable plan, program, policy, ordinance, standard, requirement, or similar provision, the local government must provide written notification or documentation of the inconsistency, non-compliance, or non-conformity. So what does that mean? By the way, so the reason why it's so difficult is because of the time frame. That notice of inconsistency must be given within either 30 or 160 days, depending upon the size of the project. And the cutoff there is 150 units. If you got a 150 unit project, they've got to give you notice of inconsistency within 30 days. Anything over 150 units, they've got 60 days to give you a notice of inconsistency. And what is the effect if they don't? And here's the real point here. If they don't give you that notice, then your project is deemed to be consistent, compliant, in conformity with all applicable plans, programs, policies, ordinances, standards, requirements, or similar provisions. So in other words, you've now applied for a housing project. The agency now has, say it's you got a 150 unit housing project. They have 30 days to tell you whether there is any inconsistency with any law, general plan policy, any other policy, program, ordinance, or standard. And if they don't give you that notice, then you're deemed consistent as a matter of law, and there's no takebacks. So, this really works a fundamental change. Let me go back and say why is this so important? Let's look at subdivision J1 again. So you've applied for a project. You got a deemed complete application. 30 days have passed. You don't have there's no notice of consistency that's been issued. You are now deemed to be consistent under subdivision J1, and the agency shall approve your project unless they make these two narrow findings that they're probably not going to be able to support. That's why it's so important, and that's why it works such a huge change in how agencies have to deal with housing projects. And I got to say, the problem for local agencies is they're just not equipped to deal with this. 30 days means, first off, it's going to have to come from a planner. It's going to have to come quickly. If your project is subject to, say, there's a public hearing requirement because you have some sort of discretionary approval. By the time you get to that hearing, almost assuredly the 30 days or the 60 days have already passed. And so, unless you have been given some sort of notice of inconsistency that you're not in compliance with some policy or standard, whether it's a area planning commission or a central planning commission or whatever board that is, design review board, whatever board that is, they're going to be powerless to make adverse findings against you, at least as far as consistency. They're not going to be able to make findings that you're inconsistent with this or that policy of the general plan, and therefore we're going to deny your project. They're powerless to do that if they have not given you that notice of inconsistency. Frankly, I have yet to see a notice of inconsistency issued. Now, I've seen situations where there's emails, hey, from a planner, hey, you missed this, you got a problem with your project here, and there's an argument made, well, that's your notice of inconsistency. But I haven't seen agencies adapt to this yet. And so I don't know whether they will. I don't know whether they can. Bigger cities like Los Angeles, I don't know how they ever could. And that's why, this J2 notice of inconsistency is so important, and why it works such an incredible change to how housing projects are reviewed and how housing projects are acted upon by local agencies. I think this is very important. You should keep that in mind as your house. Yeah.
Yeah, there's just along those lines. There's a couple of questions from the audience. They want to know, when does the 30-60-day clock start to run, and if you do fix it, if you apply and fix it, when does it start to run all over again?
Well, the first question is easy. 30, 60 days. It starts to run from when you have a complete application. Now, I'm going to get to that because SB 330 deals a lot with how you get a complete application. And, there's this new preliminary application process, or there's the traditional way, Permit Streamlining Act. SB 330 changed all that too. But it's that date that your application is deemed to be complete. That's your key date. And what was the other question, Ben? What if you?
If you get that the incomplete and you complete it, you add in whatever it is you need to submit, and you make it. Does the clock start running all over again?
Yeah, it does. And again, that's all going to be part of SB 330 when I get to it. It's now under the Permit Streamlining Act, it's 30 days, and so agency has 30 days to either deem your application complete or tell you that it's not complete. But don't confuse that though with the notice of inconsistency. Once you got there's 30-day periods for an agency to act on your application to tell you whether it's complete, and then when it's complete, then there's another 30-day or 60-day period for them to give you a notice of inconsistency. So there's two deadlines, and it's important to keep those separate. All right, some other things that the Housing Accountability Act does, and this is more litigation oriented. So not only does the HAA change how local agencies must process and deal with housing projects, it also changes the way that courts will review a decision by a local agency denying a housing development project. And here's one of the way it does. Subdivision F4 of the HAA. Now, let me premise this by saying usually, and this applies when, say, a notice of inconsistency has not been given, or a notice of inconsistency has been given, so you're not deemed consistent. So it has been given. So the agency has made a determination that you're inconsistent. So normally, in most cases, if you were to challenge that decision in court, the court would apply what's called a substantial evidence test, which is a very deferential review. It's a review that's very deferential to agency decision making. And so long as their decision that your project is inconsistent with local laws, standards, and policies is supported by some modicum of evidence called substantial evidence, the court's going to uphold that. Well, the HAA changes that and actually turns that standard on its head 180 degrees. So now it's no longer deferential to the agency, it's actually deferential to the developer. So if a housing development project shall be deemed consistent, compliant, and in conformity with applicable plans, programs, ordinances, et cetera, if there is substantial evidence that would allow a reasonable person to conclude that the housing development project or emergency shelter is consistent. So it changes the standard of review 180 degrees. And so, you know, where I see this, where I've seen this is, so for example, you have a project that is subject to a public hearing. A staff report is comes out in favor of the project, and staff report indicates that the project is consistent. Yet whatever commission that you're before, area planning commission, central planning commission, whatever it is, wants to make some adverse findings that you're not consistent. Well, the courts will generally look to that staff report and say, hey, that staff report alone is substantial evidence. So we're gonna overturn the decision of the area planning commission, which is, again, it's a very different type of review. It's a real change from how a court would normally deal with that situation. Specific adverse impact, and this goes back to subdivision J, those two findings that an agency has to make in order to deny an objectively compliant housing development project. You got to find a specific adverse impact. And here's one of the reasons why I say it is incredibly narrow. So in a specific adverse impact means a significant, quantifiable, direct, and unavoidable impact based on objective, identified, written public health and safety standards policies as they existed as of the date of the application was deemed complete. So lots and lots of adjectives there. And if, this impact doesn't meet any one of those adjectives, including objective, written, in effect at the time the application was complete, that's not going to be a basis to deny your project. And again, that's one of the additional reasons why I say, if you've got a project, your project is objectively consistent with all the zoning and general plan requirements under subdivision J1, your project is probably going to get approved. And if it doesn't get approved, then it's, you've got a significant shot at getting a court to overturn that decision. Some additional standards, again, changing the burden of proof in court. If you're in a dispute with a local agency over a denial of a housing development project, again, preponderance of the evidence. Most agency decisions are reviewed by what's called a substantial evidence standard, which I just touched on, meaning the courts are only looking for a modicum of evidence to support a finding or a decision of an agency. But under the HAA, if you've got a housing development project, the agency's findings to deny or reduce the density of your project must be supported by a preponderance of the evidence, meaning must be more likely than not, 51%, which, it's a very significant change. The local government bears the burden of proof in order to prove that their findings are supported by a preponderance of the evidence. Typically, in most other cases, the developer is going to have the burden of proof. It's a significant, usually it's a significant hurdle to overcome. It's made less so under the HAA. And if there's any doubt, and I've cited to subdivision A1L, there's a series of findings in the HAA that require the courts to interpret the HAA in a manner to afford the fullest possible weight to the interest of and the approval and provision of housing. Meaning, if there is an ambiguity in the law, if there's something that's unclear, the legislature is telling the courts, you court, you judge, you interpret this law in a way that's going to lead to these housing development projects being approved. More teeth, even more, broad standing. So not only does the HAA provide a private cause of action for a developer, your project gets denied, you of course have standing to sue the agency, the local jurisdiction, under the HAA to have that decision overturned, but it also allows housing organizations to sue on your behalf. And we've seen that. We've seen a number of housing agencies, housing organizations, private housing organizations who are, pro housing organizations, YIMBY and whatnot, get involved in these cases. And to have housing organizations on your side can be a significant benefit. If a trial court, so if your project's been denied, you sued and you've won in court, the HAA permits the trial court, if the trial court finds that the agency acted in bad faith, to order that the agency actually approve the project, which that's a significant change, because typically in a land use case, the remedy is the court sets aside the action and tells the agency go back and do it again, consistent with what I have found. So in other words, it gives, usually the agency will have another opportunity. So if there was a problem with the agency's findings, or if there's a problem with the evidence that was before the agency, it gives the agency an opportunity to actually bolster their decision to come back with another denial that a court might then uphold. But under the HAA gives the court the ability to find that the agency acted in bad faith and actually order them to approve the project. We had a case here that we litigated involving 577 housing units and a significant mixed use component down in Baldwin Hills area. Was denied by an area planning commission who decided they didn't like the HAA, didn't want to apply it. One of the reasons why, frankly, that you need to be aware of what the HAA is all about and what it provides and how it works is because a lot of these agencies, they don't like it. They don't like their power being taken away. And so, they'll intentionally skirt the rules at times. And this was a case in which an area planning commission did that. Trial court found that the APC acted in bad faith, ordered the APC to approve the project, which they did. And the penalties, there are penalties again if they don't comply with a writ of mandate and approve that project. And what the HAA provides is that there may be fines imposed by the agency on the local jurisdiction if they don't comply with the mandate. So that gave us significant amount of leverage in that case, where we had to go back to the APC to ensure that the APC approved that project. They duly approved it, because they knew that if they didn't, they tried to pull some other shenanigans, substantial fines and fines in the millions of dollars were going to be waiting for them. Some other benefits, if you find yourself in litigation under the HAA, an agency has to certify your administrative record within 30 days. The agency has to pay for the cost of the record. Those are changes from typical land use litigation, which stretches out the time that an agency has to prepare a record and delays your case. HAA cases are designed to work quickly. And I think probably the biggest benefit, if you're in litigation, is that a prevailing petitioner, you're going to get your attorney's fees back if you prevail in an HAA case. Most land use cases, you're going to bear your own attorney's fees. But under the HAA, you prove a violation, you get your attorney's fees back. Very significant. A couple more things about the HAA, and I'm going to have to move on so I can get to SB 330. General plan consistency, subdivision J4. This was actually added by SB 330. That was one of the recent amendments, subdivision J4. And in effect, what it says is that if your project is consistent with the general plan, but the general plan is inconsistent with the zoning. In other words, you're not consistent with the zoning, but you're consistent with the general plan, and the zoning is inconsistent with the general plan. The city can't require rezoning. In other words, you get to apply the standards of the general plan rather than the zoning. And where we see this most often is in density limitations. So a lot of times what you'll see is, your property is zoned a certain way, but the general plan has you designated into some other density category that allows additional density than what your zoning would allow. Well, the HAA says you get to take advantage of the additional density under the zone. And again, if you know, as long as you get to take advantage of the additional density that's supplied by the general plan, and you are still deemed to be consistent with the zone. So you still get to take advantage of subdivision J1, which, as I said, is almost going to guarantee your project gets approved. Some folks might be asking themselves, well, how does this work with density bonus? If my project is eligible for a density bonus and I take advantage of a density bonus, am I still consistent with the zone? Am I still consistent with objective standards? Do I still get the benefit of subdivision J? The answer is yes. The receipt of a density bonus shall not constitute a valid basis on which to find an inconsistency. So yes, your density bonus project is subject to protection under the HAA. And again, so long as you're consistent, your project, your density bonus project is consistent with all of the other objective standards, parking, FAR, height, everything else, they're almost assuredly going to have to approve your project. A little bit of bad news, unfortunately. HAA is not a CEQA get out of jail free card. You still have to comply with CEQA. I suppose the silver lining there is that most HAA projects are probably going to be exempt under, you know, some kind of TOC or Class 32 exemption, but it's not going to stop someone from challenging your exemption, stop someone from appealing your CEQA determination. Oh, by the way, stepping back, I mentioned TOC. So just like HAA does work with density bonus, HAA is also going to work with TOC. So if you're getting additional density through a TOC incentive, and your project is consistent with the other objective requirements of the zone, you're going to be consistent with the all of the local requirements, and you're going to be protected under subdivision J1. The other bad news here, I think, under subdivision E is the Coastal Act, because you still also have to comply with the Coastal Act. Unfortunately, the Coastal Act does give local agencies, Coastal Commission, lots of discretion to do whatever they're going to want to do with housing development projects. And so that's a tough subject. I could probably do a whole hour on that subject alone. What does HAA and Coastal Act, how they interact?
I think we'll schedule a whole webinar, I think, on Coastal Act and housing. I think that's a great idea.
Yeah. But the way that courts have thus far approached the situation, I'll just say this, is that thus far courts will generally say that the Coastal Act trumps the Housing Accountability Act. That's how I've seen it apply. I think there's fantastic arguments for why that's wrong, but again, that's a long story.
I do want to add, I've been trying to answer some of the questions in the chat box, and one of them was that issue of whether CEQA, how CEQA interacts with the HAA. And I will say, I think it's a question mark. We're still figuring that out. At least that was my response to the question. But I agree. Right now, it's certainly not settled that AHA is a superseding law. Okay.
Yeah.
Sorry.
Yeah.
I know you got more to go.
You know, I'm going to bypass this. There was a Court of Appeal decision, September 2021. There's the site. If you want to pull up the case, read it. It's an interesting case. It's now the leading published authority, the latest word out of the Court of Appeal. I think the big ticket item here is that this Superior Court, the trial court in this case, had actually ruled that the HAA was unconstitutional under the California Constitution because it usurped local powers. And so this was kind of a big deal. Court of Appeal said, no, you're wrong. It is a valid exercise of state legislative priority, and upheld the validity of the Housing Accountability Act. Housing Crisis Act, I know I'll only have a few minutes. I want to point out what it does. So the Housing Crisis Act, SB 330, was kind of a hodgepodge of new standards. It amended the HAA in ways, it amended the Permit Streamlining Act in ways, and it created some additional new standards. one of the things it does, it creates this new preliminary application process. I think that this is very important because what it does, it helps you to get to a deemed complete application. So, and it, you know, it identifies the information necessary for the preliminary application. And so long as your application meets those statutory standards, they can't ask you for additional things. You won't get caught in that, you know, application time loop that you might have found yourself in. At that point, you comply with that, you get a deemed complete application. Why is that important? Two things. One, it actually provides you an earlier vesting period. So once you've got a preliminary, an approved preliminary application or a complete preliminary application, your vesting starts then. So no new laws, they can't apply new laws enacted after that date to your project. So it's an earlier vesting period. And again, that's going to start that notice of inconsistency date. So now they got 30, 60 days from that date to give you notice of inconsistency. So very, very important. No more than 5 hearings for a project. Some of you may have been involved in projects, you know, involving hearing after hearing after hearing. Housing Crisis Act says no more than 5, and that's going to include things like design review hearings, neighborhood council hearings, et cetera. The problem with that is that, I mean, there's no real remedy that I've seen, certainly not spelled out in SB 330. And, you know, if an agency has held 5 hearings and you need another hearing in order to get your project approved, I don't know what you could say. You still got to get that project approved. So that may be kind of a little toothless, you know, standard of, you know, aspiration rather than application. The housing project consistent with objective general plan policies do not require rezoning. I went over that. That came from SB 330. The other thing that I think is important, a couple other things. Permit Streamlining Act. Again, I touched on it briefly. The agency's got 30 days to make that determination. They're limited in the things that they can ask for. You should know this for your project because, you know, agencies will continue to ask for more and more and more things, and you'll never get to a complete application. And it's so important to get to that deemed complete application because that's when, you know, deadlines run for agencies to act under municipal code. That's when deadlines run for that notice of inconsistency. And look, here's a real tip. And I've seen problems with this because agencies won't document sometimes when they have determined your application to be complete. And you should be doing that because it's not so clear when it comes later on and you're now in a dispute over what laws apply and whether, you know, you've got inconsistency determination or not. It's not so clear when your application was deemed complete. So you familiarize yourself with the Permit Streamlining Act and SB 330 and how that works, or have someone that can advise you when it does as you're in that process, because you're going to want to document that date because the agency won't do it for you. And later on, if you're in a dispute, you're going to want to know, you're going to be able to prove, hey, I've got a deemed complete application as of this date, and all those deadlines ran and expired. So that's a very, very important thing to know. Last thing under SB 330 that I want to point out is the density freeze. So what it says is that an agency may not lower density for properties where housing is an allowable use, so not just residential properties, but commercial properties or other zone properties where housing is an allowable use. They cannot reduce the densities that were below what was permitted as of January 1, 2018. And that applies not just to direct density limitations, direct density reductions, downzoning, but also other development limitations, such as minimum lot sizes, changing minimum lot sizes, changing minimum frontage requirements, or whatever might be enacted that would have the effect of reducing density. Any kind of new ordinance like that enacted after 2018 is void. Now that actually sunsets, and I think it originally sunsetted in 2025, but that has been recently extended to 2030. So there's a density freeze. That's the other important thing about the Housing Crisis Act. Lastly, I just want to point out, courts, what I found in my experience, they do enforce the HAA and SB 330. And I've just provided you with a list of cases that I know about from all over the state, Los Angeles, Alameda, Orange County, Santa Clara County, where courts are enforcing the HAA. Every single one of these cases, by the way, the developer has prevailed. Several of those are cases from us. There's other cases other firms have handled. But in all of those cases, the developer has prevailed. And the reason is because all of those standards that I've just went over, and I know I've taken up all of the time, 1 o'clock. So as I said, there was a lot of information to go over. I could probably talk for another 2 hours over some of these things, but I do appreciate that. Do we have any questions, or have we answered the questions? I know we're at 1 o'clock.
We have a lot. There are a lot more questions. Some of them you have answered, and specifically, but I think we need to respect the 1 hour time limit here so people can get back to work.
Sure.
But I think what this does tell us is the great interest, the many of the subtopics here. I think what we will do is we'll think about presenting some additional webinars on some of these more nuanced topics. And that allows us a chance to do a deep dive into some of these issues. Thank you, Matt. Terrific presentation. And thank you, Daniel, for organizing it and working on it and answering some of these questions. And I think with that, we're going to bid you all a good afternoon, and stay on the lookout. We may publish some additional webinars, so we'll email you all. Okay, have a nice rest of the day. Thank you. Goodbye.
Thanks.